What's up, everybody? Welcome to the stream. We in the stew, baby, and it's day 13. Feels like the longest 13 days. I don't know, frick dis. Now, we are pretty far behind, and that's okay. That's okay. We want to skip all the BS. Welcome to the stream, the channel, if you are new. Now, we're going to jump right in. Like I said, we do not BS over here. We do push back a little bit so we can skip all of these pauses. I do have some information that today was a little wild this morning, and she knows who she is feeding the information here. We also have some people inside the court that have told me, okay, I got some inside information for you all, that it has been very tense in the courtroom. It does not feel the way that it looks, if that makes any sense. So from my source in the courtroom, okay, I have been told that what we are seeing on TV is very different than what it feels like to be in there. And I think that that's interesting because, again, we are watching this from a completely different perspective than what it's like to actually be there, to be around the people who are involved, and to, you know, see this all happening in real life. But to us, it feels very disjointed. And to us, it feels very messy, and, you know, the breaks are so long. But if you're there, you get up, you go take a break, you go drink water, you talk to people around you about what's going on. It's very different. So just letting you guys know that from the insider perspective, it does feel a lot more tense and a lot different in person. That's what I'm being told. So we are going to jump in here, get started. No more wasting your time. And we're going to skip everything that we possibly can today. It seems like a lot of arguing is going to be going on this morning. We're basically back where we were yesterday.
At the same time, I'd appreciate it, Katie.
Are you pulling up the Celebrate one?
Yesterday we ended with...
So it's up on the screen right now. So it starts with Bates number state, STATE, 0335281. And this was produced to us before the state went through and updated the time. So this is on UTC time instead of Mountain time.
Okay.
At some point in this case, and there have been so many supplemental, I think we're on our 10th exhibit list. I think we're, you know, anyway, hundreds and hundreds and hundreds and hundreds of alterations and substitutions. But this is the one we got before they had changed the UTC time, which was confusing to everybody. And so they went back and redid that. This version, they had not changed it yet to Mountain time. This is a consecutively numbered, Bates numbered document. There's no pages missing. This is coming from a Celebrate extraction of Eric's phone that was seized by Mr. O'Driscoll. We just found the Celebrate.
Yes, O'Driscoll,
and
that's his
extracted
name.
by Miss Gibson.
Can you show me the Cellbrite
Yes,
version
sir.
of
We
this?
are. We can, and we're pulling it up right now.
It's a very big file, so what I've done is I've emailed Katie the cover page, and then I'm working on the box download, so she can download it.
Yeah. Forgive me. And this is a nuts and bolts question.
Sure.
Forgive my ignorance. I'm looking at one page that shows 3 text messages total.
Right.
Typically, these are a complete string that has a Cellbrite header. Where is that version of this text?
So not all of the ones we've introduced in this trial have the Celebrite header. Only some of them, not
I
all
don't
of them.
know if is that true. I thought
That's
all of them had the
No.
Cellbrite header.
No, that is not true.
Hold on, let's pause there for a second, because I think that's how we've been laying foundation for the admission of them so far. Foundation.
Right.
Mr. Bloodworth, is my memory correct? Unless they came from, I mean, we've had CDR-related metadata regarding text messages. We've had some non-bubble related or non-bubble depicted cell messages that have come out of other extractions. But in terms of blue and green bubbles, I thought all of them had a Cellbrite header.
Yeah, I believe that's right, Your Honor. If we prepared an exhibit that comes from a Celebrite extraction, it has the Celebrite header.
Right.
There's others where we just, you know, we've got texts from other means. Somebody sent us forwarded this text, right?
Right.
But if
Screenshots, for example.
correct,
Yeah.
if it comes from a Celebrite extraction, as best I recall, it has the Celebrite header.
Okay. And Ms. Nestor, I'll give you the record back here in a second, but it's also unclear to me, is this 3 text messages that we're talking about, are they part of a larger exchange that has already been admitted?
So,
Let me ask you a question. Do you guys want to hear all this, or do you want me to just skip back to O'Driscoll? Put 1 in the chat if you want to skip all the way to the testimony, 2 if you want to hear all of this. Because I honestly don't need to hear the back and forth. So my vote is skip to testimony. Let me know. 1 if you want to skip, 2 if you want to just watch all of it.
these are all the text messages he had with Kouri on the day he passed, on the 3rd.
On the 3rd or the 4th?
He died early morning in the 4th, so it's from the 3rd.
Okay. These 3 bubbles are the sum total of their text
All right,
traffic on
we're
the
No,
skipping.
third?
we have more than 3. There's
This is
just a
all
minute.
just
There's a couple
fluffity
pages
fluff
to it.
fluff. Oh my word.
It's the last set of texts
Oh
that they.
Lord God.
There's multiple. See, that's. The
Oh
second
heavens. Okay. Oh my gosh, brother. Man, was that a long time of nothing. I'm glad we're not watching this live. I wouldn't want to sit through this.
Detective, please step in front of Brittany. We'll get you sworn back in.
I couldn't sit through all this. This is ridiculous.
Do you solemnly swear the testimony you're about to give in the matter before the court to be the truth, the whole truth, and nothing but the truth, subject to the pains and penalties of perjury?
I do.
Thank you. Have a seat.
Exactly. Ms. Nestor, please proceed.
Thank you, Your Honor. May it please the court. Good morning, Detective O'Driscoll.
Good morning, Ms. Nestor.
I believe when we stopped yesterday, we were talking about the GIFs or GIFs. And I want to start by having you review a document that's been agreed to by the parties. It is exhibit number 3-40. And at this point, Your Honor, we're asking to admit it per stipulation of the parties.
So the witness can see 3-40. And do we want to publish now, counsel?
Please.
Mr. Bloodworth?
No objections.
State's exhibit 3-40 is admitted.
All right, and this was talked about when, I believe it was Mr. Kostradimos, I think, it's all blurring together now, was on the stand. But this is the group of all the GIFs or the GIFs that were in kind of a group, and included the ones that were accessed on the morning after the police left Ms. Richins' home, after Mr. Richins passed. Do you remember the testimony about that?
Yes.
Okay. Can we go to the page that shows the GIFs in question?
GIFs.
Maybe blow that up at the top.
Say it right. I'm getting pissed. It's
Okay.
GIF with the G.
So
G.
I think that's 2 of them. One of them is from, I guess, the movie Dumb and Dumber. And the other one is our president. And I think there was a third one, but it's, yeah, Mr. Spacey and
Mr. Spacey.
in a TV program, right? And those are the 3 GIFs that were talked about.
GIF.
And if you blow up the time that they were accessed, they all were accessed at 8:29:03 a.m. on March the 4th. That's the day that Mr. Richins was found deceased, correct?
Yep.
Correct.
How wild is
Right,
that?
and I know we've already heard the testimony that these are what we call orphaned GIFs. You can't really tell which text they came with and exactly when they were sent or who they were sent to or by. All we know is that they were somehow accessed at that point by her phone, correct?
That was
Come
the
on,
testimony,
bro.
Mr. Cocherdemos. Yes.
Okay,
Accessed.
can you pull up another one of the photos that is the picture from the house?
Look how nervous she is.
That's it.
She's nervous as hell because she sent
All
these
right.
that morning, the next
This
day.
is another picture that was accessed at that exact moment at 8:29. And can you blow the picture up a little bit? Do you recognize what that is?
Is that her
photograph?
property she's selling?
It's the legacy home.
There you
It's
go.
the legacy home, right? And was there another photo that was accessed that same morning, also orphaned? Can you find that picture? It's right above it, I think. There we go. Can you blow that picture up a little bit? Thank you.
You can't see
All right.
nothing.
And is that also just a closer up view of the legacy mansion?
Sure.
It appears so. It's very,
Very
blurry on
grainy.
my screen.
It is. I think it is blurry. And then can you back out and show the time that one was accessed according to this same group of photos? That one appears to have been accessed at 10:42 a.m. the same morning.
She didn't give two shits
That's
about Eric.
what this document says.
She cared
yes.
about that
Okay.
damn house.
Now,
and making
if
money.
we could put just on the witnesses screen, exhibit JO, I think it's 11, not for the publication yet, Your Honor.
Understood.
All right. And can you take just a moment and blow that up just a little bit so he can read it better? All right. Just take a second and scroll through that and tell me if that refreshes your recollection about any documents you reviewed about Eric's final communications before he passed.
Your Honor, objection. There's no foundation to get to whether or not his recollection requires refreshment.
Yeah, let's pause there. Would you lay a little bit of foundation before we get there?
Sure, and it requires us to go back to yesterday. So yesterday I had asked you right before we stopped if you had, as part of your investigation, reviewed the final communications of Eric right before he passed away, and you mentioned you had. Is that correct?
Yes.
All right. Based on that, if you could refresh, do you recall the communications you reviewed that day?
Not all of them. Some of them, yeah.
Can we then please blow up this document in front of him and see if this refreshes your recollection as to what you reviewed?
Mr. Bloodworth, the witness doesn't have it yet. Any objection to that question?
Your Honor, I think the objection foundation, I think there requires additional foundation.
I think the question pending is, are these among the things he reviewed, correct?
Maybe I misunderstood the pending.
Yeah.
That's the question.
So I think,
Can we back up a step? Maybe I'll catch up.
sure.
Is that
Ms.
funny?
Nestor, ask your last question one more time, please.
Are these texts that are before you part of what you reviewed from Eric's final communications on his phone?
She's on my
Go
last
one
damn
step
nerve.
before that. He hasn't seen these yet. He doesn't currently have them in front of him.
Do you recall all of the communications you saw that day when you were reviewing Eric's final communications?
All the texts from his phone
Yes.
on the day before he died?
Yes.
I don't remember all of them. I
Okay.
remember some of them.
So then, would you please look at this document and see if it refreshes your recollection and as to whether these were included in his communications?
Any objection, Mr. Bloodworth?
Honestly, how do you think she's innocent? Right?
The witness can now see what you're referring
What
to, Ms.
what
Nestor.
has the
Thank you,
defense
Your Honor.
presented?
Can you go down just one more and maybe blow that up
Nothing.
a little, that photo?
Unbiasedly,
Does this refresh
nothing.
your recollection, these communications of Eric's and Corey's the day he died?
These are time-stamped March 3rd. That's not the day he died, but the day before he died.
Totally correct, because he died in, we think, the early morning hours of the 4th, right?
Yeah, he was pronounced deceased on the 4th.
Okay.
Yes, Your
So,
Honor. Sorry, objection foundation is to the meaning of died, right? He was pronounced dead on.
But I think the witness and the questioning lawyer have a common understanding here. Overruled.
Thank you, Your Honor. Okay, so were these included in what you reviewed in the communications between Eric and Kouri on the 3rd of March?
Yes.
All right. And this photograph, if you could blow that up.
Your Honor, objection, his recollection has been refreshed. I think the exhibit can now be set aside.
I'm not publishing it. I've just got one more question
Lady.
about the photo, and then I'm done.
Stop.
I'll take it down and ask your question. If we need to refresh again, you can.
Okay, thank you.
Okay.
Wait, did you tell me I could ask the question?
Yeah, I took the photo down. Ask whatever you're about to
Yes,
ask.
yes.
Okay.
Does the photo that you just refreshed your recollection with match the same photo that we just saw in 340? That was the corner of the Midway Mansion.
Your Honor, the photo's still up on my screen, and the witness is
My apologies. There you go.
staring at it.
Sorry.
Ooh.
Is it the same photo, sir?
This one that we just saw that was enlarged, you're asking if that's the same as the one in the text message?
Does it match the one that we just put on the screen for the jurors that came with all those other pictures that morning?
Yes.
Thank you. That's all I have. Done with that. I'm sorry. Maybe I'm not. Can I have just one moment, Your Honor?
I'm sorry. She's getting on my last nerve. I'm really trying to be nice. It's so unprofessional. She just talks over everybody. It's like what my problem was with Pryor. If you're a great defense attorney, I'm not going to care. I'm not going to be mad. It's like you're just it's too unprofessional. It's too outbursting. It's cutting people off. Gosh.
One more step. If we could go back to 340, which has been admitted, and pull up some additional gifts that were accessed at that same time. If we could pull those up, please.
Sure. There you go.
Okay, so there's the picture on the bottom left-hand corner of the Midway Mansion house, right?
Popping champagne.
Yes.
And that one was accessed at 10:42 a.m. the morning of the 4th.
Yes.
And the one with the champagne is also that exact same time.
Dancing and champagne.
Yes.
And the one with the farmer is that exact same time.
Yes.
And we know for sure that the one on the bottom left was sent the day before. Because we just looked at that, right?
No.
And you refreshed your recollection.
No.
Yeah, I don't know if the part of the extraction that we're looking at right now is saying that that's where that came from. I don't know if that's the same file path, but that photo is the same.
Perfect, thank you. Okay, we can take that down now. All right, I also want to talk to you about, sorry.
Your
sorry.
husband dies and you start
I also
sending
want to talk to
champagne
you
and money.
about the
Yes.
Google searches that were testified about here that were on Ms. Richins' phone or computer or both. Did you review those as part of your investigation?
Yes.
All right. And were you able to determine dates on all of those searches when they were made?
I don't believe so. Yeah, that would be a question for Mr. Kotradimos. I remember seeing the searches and the text of the searches, but I believe he testified that that there wasn't a timestamp associated with them and that they differed from the action in the phone that showed that a link was actually clicked on from one of those searches.
Okay, perfect.
And I believe those had timestamps.
Okay, the links, but maybe not the searches.
Correct.
Thank you for that clarification. And you agree that as of April the 13th of 2022, approximately a month and a few days after Eric passed away,
Thank you, love, anyway.
that Ms. Richins' house was searched and she was detained in a police vehicle, right?
Objection,
That
Your
wasn't to
Honor.
do with anything.
Foundation.
Foundation, yeah.
Sustained. Lay a little foundation there.
He
Are
really
you
gives her a
aware
lot of
that there was a
leniency.
search conducted on her house on April 13th?
On Miss Richins' house?
Yes.
Yes.
And are you aware that while that search was being conducted, Ms. Richins was temporarily detained in a police vehicle for a period of time?
Objection, Your Honor, calls for a legal conclusion.
Overruled on that.
Go ahead.
I think the word detained is the problem there. I think there's been dispute over whether or not she was detained. But she was spoken to. She was asked to wait in law enforcement's vehicle until the lead detective could come speak to her about what was going on with the search.
Okay. So the searches on the website, fair to say that all of those searches are believed to have occurred after April 13th of 2022?
I don't know. Like I said, I don't know there were timestamps on the searches, so I can't be sure.
Did you ever interview any of Kouri's family or friends and ask them if they were responsible for any of those, or if they'd ever seen Kouri do it, or who did those searches?
No.
Okay. All right, I'd like to talk about the orange notebook for just a moment. We pulled up, do we have the, do you have that orange notebook exhibit? I can't remember the number of it. Court's indulgence for just a minute, I have the number. I've got it. I'll tell you. Just one moment, I'm sorry, Your Honor. It's hard to keep all these exhibits straight. Can we put up Exhibit 2-66R? It's admitted, Your Honor. Oh, wait, I'm sorry. Before we do that, can we put up Exhibit, 2-66R? That's correct. We don't have they redacted part of it, and we don't have that.
Scott, 2-66R, please.
Would he be so kind? I don't want to accidentally put something up that was redacted, Your Honor.
My apologies. We'll fix that. It's okay. One moment, please. Scott, if we do our normal dance, I'd appreciate it.
Yes. No problem, Your Honor.
2-66R. Publish.
Yes, please, Your Honor.
There you go.
All right, and can we, that's what we like to call the orange notebook, right? Because it's like in an orange kids' school notebook, right?
Correct.
Okay, and can you fast forward, Katie, to, until I tell you to stop? Keep going. Keep going. Keep going. Keep going. Okay, right there. And can you blow out the bottom third of the page? All right, so this orange notebook that was recovered from the house, you don't have any knowledge about the circumstances under which it was prepared, do you? Or why it was written?
I do not.
And you don't know when it was written?
No, I don't.
And this was seized the day Ms. Richins was arrested, which was May 8th, 2023, correct?
I believe so, yeah.
So over a year after Eric's death, right?
Correct.
All right, and here on there is an entry that says on March the 22nd, can you highlight that please, Katie? Kouri starts counseling. Do you see that? Oh, you need to say yes.
Yes,
Okay.
sorry.
Did you take any steps to verify if that actually was the date she started doing mental health counseling?
I didn't learn anything about her counseling from interviews that we conducted. We did get Kouri's medical records, and I don't remember if a mental health counselor was part of those, but that's possible.
And I imagine as a, I forgot the word you used, as a serious crime investigator, homicide investigator, detective, death scene investigator, you've dealt with a lot of victims and family members who've been traumatized by a death and have required counseling. Is that fair?
My involvement with victims doesn't usually go that far to know whether they sought counseling or not. We refer them to the Victims Advocate Service, and they're much more equipped to help them with that.
Great. And have you ever heard of what's called trauma journaling?
No.
Do you know what that is?
No.
Okay.
Your Honor, maybe approach on.
I'll move on. I'm done with that. He
Are
doesn't know,
we
so I'll
approaching
move
or
on.
moving on?
Well, if we're moving on from the subject matter, no need to approach.
Got it.
We are moving on from the subject matter.
Very good.
All right, you also talked about the fact that you found it, I think you said suspicious, but I don't want to put that word in your mouth, but it was of significance to you that Carmen had placed a Mr. Richins' obituary on her memory wall or her inspiration wall or whatever. Is that right?
I noticed it, yeah. I mean,
Okay.
it was something that caught my eye.
Did you happen to notice if there were any other obituaries right around it or next to it?
No, I didn't particularly notice.
Can we pull up exhibit? Yes, thank you. The second one, 816R, I think. Oh, it's 15? Okay, 815R. And that's in, Your Honor, if we could publish it.
I can't see it yet, Katie. Oh, you don't have it. My apologies.
Oh, that
Scott,
one's got things
Would
blurred.
you help us out? Thank you. Let's see. This is
Yeah.
8-15R. Let me just make sure this is the one you intended, Ms. Nestor.
That is the one.
And Judge, Katie does have this one if you wanted to switch back.
Okay.
Yeah, because I'm going to need her to blow it up. Can we
One
switch it
more.
back to her, please? I'm so sorry.
No problem.
There was a recent version where they blurred a lot of children's faces out and stuff. Okay. Do you remember this picture we introduced of Mr. Richins' obituary on her memory wall?
Yes.
Can you please blow that up, Katie, to show what's right beside it or right under it? Do you see another in loving memory right below it?
Yeah, it looks like a program pamphlet from a funeral.
Okay. All right. Also, the C&E hat, I believe, that was on that wall that you noticed. Did you do any investigation to determine if Carmen actually, if Carmen actually did any work for C&E?
Yeah, based on our conversations, she never worked for C&E as a company. She did work on the Richins house. She interacted with Eric, but she was never employed by C&E.
Okay. All right. I also want to show you a text. As part of your investigation of reviewing texts between Eric and Kouri, Katie, if you could pull up Exhibit 2 dash, I believe it's 9. 2-3. Thank you. That's it. Before you look at that, do you recall trying to determine, investigating whether or not Kouri was aware prior to Eric's death that at least some, maybe not the house, but at least some of the assets that belonged to them or to Eric were shielded under some kind of a trust, if she was aware of that before he passed?
Yeah, that was part of our investigation.
All right. And did you review conversations she had with people about that and texts about that and things about that?
I didn't have any recorded conversations that she had. I guess it depends on the timing that you're asking about.
Okay, I'd like to refresh your recollection and see if you look at these texts, if it reminds you if this is one of the things you looked at in trying to make that determination, okay?
Okay.
Can you blow that up? It's Exhibit 2-3D as in Delta. And just let him look at all of them, please, just slowly. Give him plenty of time to read. Can you go back up? I think we're missing that one. There you go, the next page. Does this refresh your recollection? Do you remember looking at this set of texts between Kouri and Eric?
No, I didn't have time to finish reading that.
Oh, sorry. Keep letting him read it.
Okay.
Does that refresh your recollection? Do you remember reviewing this series of texts between Kouri and Eric relating to the trust?
I don't remember, and the context of those messages, I can't say that that's what they're talking about.
Okay, so this does not refresh your recollection.
No.
Okay, court's indulgence for just one moment, Your Honor. Your Honor, may I approach the state?
No, that's not true. It's hearsay.
We're working on something, but I'm going to ask a couple more, move back, and then we may come back to it once she's done looking. So was it your understanding, without saying anything anyone told you, when you were conducting your investigation, did you become aware that Kouri knew of at least some portion of some aspect of the trust being created before Eric passed?
Objection, Your Honor. More foundation, otherwise it's based on hearsay.
The foundation objection is sustained based upon the witness's prior answer. If you can start smaller, maybe build up to it, there may be some foundation here.
Did you interview people, look at documents, review texts to try to inform your investigation as to whether Kouri knew that Eric had created a trust for at least some portion of their assets prior to his death?
I reviewed information about the trust from several different sources. Everything that I reviewed suggested that she was not aware of how the trust worked or the consequences of the trust.
Totally fair. I think you're right about that. But was she aware that it existed?
Objection, Your Honor. Same foundation objection.
Overruled based upon his prior answer. You can answer, Detective.
I can't think of a specific instance, but I think there was some information that might have suggested that.
Okay, thank you. All right. now I want to talk about Valentine's Day. You were here when Ms. Staking testified to the jury that in a conversation with a bunch of friends, there was some joking references made to Kouri wanting to poison Eric, and then Eric stating he had an allergic reaction and used an EpiPen. You heard that testimony, right?
Objection, Your Honor, foundation. That's not what happened.
I think your recitation of Ms. Staking's testimony was correct until the last either sentence or clause.
Okay. Did you become aware that at least in some context there was a discussion on about the Valentine's Day incident relating to Eric taking an EpiPen, using an EpiPen?
Ms. Staking, from my memory, testified that there was a comment made by Eric in a joking manner that Kouri had tried to poison him. And then she said that Kouri's explanation was that it was an allergic reaction.
And that he used an EpiPen, right? Didn't she say that was the very last thing she said, I think?
I think so.
Okay. So did you do any investigation into whether or not Eric was treated regularly for allergies?
Yes.
And in fact, he had an allergy doctor, is that correct?
Yes.
And he had an EpiPen device in the master bathroom that was recovered during the first search.
Probably. I know that there were some located in the refrigerator on one of the searches. EpiPens, that is.
Did you ever investigate whether Eric discussed this allergic reaction with his doctor, his allergy doctor?
I believe one of our investigators contacted the allergy doctor and conducted an interview. I don't remember what the results or content of that interview was.
Did you determine what Eric was allergic to? Was he allergic to avocados or wheat or peanut oil? Do you know?
From what I remember being told by the investigator that had that conversation, it was like seasonal allergies, trees, grasses, dander, things like that.
Okay. Were you ever able to confirm that Eric ever sought any medical treatment for what allegedly happened to him on February 14th?
Just that in his text message, he mentioned that he might go to the hospital. So I don't know for sure if he did, but he was feeling bad enough that he thought he might need to.
Were you ever able to confirm that he did?
No.
Okay. All right, I want to also talk to you about Miss Susan Kohler. Do you know who Susan Kohler is?
Yes.
Who is Susan Kohler?
She's an associate of Carmen Lauber's. She worked for Doreen Kouri cleaning houses with Carmen Lauber.
Okay. And in the course of your investigation, what did you determine, if anything, was the role that Susan Kohler played with respect to this case?
We determined that she sold, I think the number was 15 to 20 Roxy's or prescription narcotic pain pills to Carmen at the request of Miss Richins.
Okay. And was Miss Susan Kohler offered immunity like Crozier and Carmen Lauber were?
Objection, Your Honor.
Do you know?
What's the basis of the objection, Mr. Bloodworth? Or do you need to approach?
Relevancy.
Approach for 1 second.
So just to recap a couple of days of testimony that got interrupted a lot. This investigation has now extended for a period of over 4 years, right?
Correct.
Okay. And during that 4 years period of time, as recently as less than a month ago, you were still issuing search warrants. Is that right?
Yes.
And there were a total of at least 10 searches by law enforcement of Ms. Richins' home. Is that right?
There were 10 search warrants issued, yeah,
And
or around 10.
you heard that there's also at least 5 multi-day searches by a private investigator. Is that right?
I don't remember if it was 5 days. He said a couple days.
And the agencies that were involved in this case were the Summit County Sheriff, right?
Correct.
The Medical Examiner's Office.
They're not a law enforcement agency.
Well, they have investigator, right? She testified here.
Yeah.
Okay.
They're a civilian investigator.
Fair. Also, there was a private investigator that was involved in this case and communicated with you and provided information.
No, he was involved in the civil case.
Did he provide you information?
He provided our office information. I never talked to him personally.
All right. The DEA was involved in this case, at least briefly.
They never took any official action. Well, I should restate that. They assisted us with forensic tools,
Okay.
like call detail records and things like that.
Homeland Security agent, or I'm sorry, U.S. Postal Service agent was at one of the searches, right?
Yeah, I was aware of that.
We've heard, I believe that we're over 45 witnesses now in this trial. Is that right?
I haven't been counting.
And in all of that, we have no murder weapon. Like, you haven't found anything that was connected to Eric's death. No fentanyl in the house, correct?
There was a boatload of fentanyl in his stomach that came out of the house with him.
Other than this, what's in his stomach? Did you find anything else that had fentanyl in it?
No,
Okay. You can't say how the fentanyl was administered, right?
orally.
Besides orally.
That's all I know is that he took it orally.
We don't know exactly when it happened and what time of night or morning.
We know a time range.
Okay. You can't say the dosage that was ingested, right? 1 pill, 2 pill, 20 pills.
Illicit fentanyl does not come in dosages.
Okay. You can't say what was ingested on Valentine's Day at all, correct?
Fentanyl is definitely ingested. Oh, I'm sorry, on Valentine's Day.
Yes, on Valentine's Day.
No, we don't have any kind of medical examiner's report of his stomach contents from that day.
And on insurance fraud, we have not heard any testimony about any representations that Kouri Richins made to her insurance company, have we?
Objection, Your Honor.
If you put a word to it. Foundation.
Well, foundation also probably then hearsay.
Would you approach for 1 second?
Ever said Kouri?
State's objections are overruled. If you would restate that question, if you can, exactly. as
I will.
necessary.
And we've not heard any testimony in this case about statements or representations Kouri made to her insurance company, correct?
Not statements. We've heard evidence about it.
Okay. And with respect to the forgery count, we've not heard any testimony one way or the other whether Eric gave Kouri permission to sign his name on documents, have we?
I don't think that's required to meet the forgery statute.
Have we heard anything about that? Do you know one way or the other whether Eric allowed Kouri to sign his name on documents as a married couple?
No, but that's still signing someone else's name, even if they give you permission, purporting it to be somebody else's signature.
Okay, well, the judge is going to instruct the jury on what the law is about that. But what I'm asking you is, as the investigator, do you have any knowledge one way or the other if Eric ever said to her, hey, it's okay with me, sign my name, I don't have time to deal with it?
I don't know.
And in fact, what we have heard is that he did give her at least one power of attorney at some point years ago, right?
Objection, well, not objection, may we approach?
Sure.
Thank you. Detective O'Driscoll, in this case, are you the lead investigator among many investigators?
Yeah, it's a large team. I've had a lot of help.
Does your job in part involve coordinating the activities of all the other sheriff's office investigators?
Yes.
And are you the lead investigator for the sheriff's office as opposed to the county attorney's office?
Correct. I have no authority over what the prosecutor's investigator does.
And does the county's, well, you may have just answered this, but does the county attorney's office have its own investigation capability and authority?
Yes.
Is it your job as lead investigator to be omniscient regarding every investigative detail in this case, to include details of the county attorney's investigation?
No, I can't know every single detail. It's, as defense knows, terabytes of information.
And in early 2023, was your personal investigative focus on determining the source of the fentanyl that caused Eric Richins' death?
Yes, because like I said at the beginning, I came into the investigations division as a narcotics officer. Before I became the lead investigator on this case, that was our focus, is investigating drug-related crimes.
In early 2023, did the sheriff's office have a digital forensics capability even remotely close to the capabilities of Mr. Cochodimos?
No, that's why we hired him.
And in early 2023, did the sheriff's office have any forensic accounting capability whatsoever?
In which year? Which date did you say?
Early 2023.
They had a little. I mean, how early? Not until March and April.
Well, let me ask you
January, zero.
And any forensics accounting capability close to that of Brooke Carrington?
Oh, I'm sorry. Did you say forensic accounting?
Forensic accounting.
I'm sorry. I misheard. I thought you said digital forensics. No, the sheriff's office has no experts in forensic accounting.
And is part of the reason that they have no forensics accounting experts and minimal digital forensics experts because you have a small office, right?
Yeah, it's relatively small.
Did the county attorney's office become involved in this case in early May of 2023 when me charged Kouri Richins?
Yes, we only met with the prosecutors about a week before to give them our probable cause information.
Subsequent to charging Ms. Richins, did the county attorney's office engage Mr. Cochodimos and Ms. Carrington?
Yes.
And is Mr. Cochodimos the investigator who analyzed the digital forensics, including cell tower mapping and cell phone data?
Yes.
And was it Ms. Carrington that investigated and analyzed the forensic accounting, including the closing on the Midway Mansion?
Yes.
And does the state provide the material from each of their investigations to the defense in discovery?
As far as I know, yes.
Do you recall in cross-examination when defense counsel picked a sentence from a May 2023 interview of Carmen Lauber, where it was either you or Detective Maynard told Carmen Lauber that she was something like the biggest piece of the puzzle?
Yes, I remember that.
What was the context of that comment?
She said something about, can we just lay out all the information, all the pieces in front of us? Because we were trying to establish a timeline. And we told her, you're the biggest piece. You're the biggest part of the information that we don't know.
And
she
did-
had the information.
Sorry, I didn't mean to interrupt you. And did that context involve a piece of the drug purchase timeline rather than a piece of this whole giant case?
Correct. The timeline of her involvement, not necessarily the entire case.
And did that interview predate any information on the forensic accounting?
Yes.
And did
We
it-
didn't even get into that until well after.
And did it predate any of Mr. Kotodimos' investigation?
Yes.
And did it predate your understanding of Kouri Richins' relationship with Josh Grossman?
Yes.
Do you recall whether that empty 2016 hydrocodone bottle that went with Eric Richins' body to the medical examiner's office, was discarded by the medical examiner's office in August of 2022?
Back to hearsay.
Please lay some foundation. Sustained.
Do you recall what happened with the empty 2016 hydrocodone bottle?
Need my objection.
Detective, it's a yes or no. Start there.
Yes.
How do you know what happened with the 2016 empty hydrocodone bottle?
I was told by other investigators that they're
Objection.
Sustained on hearsay.
Did you or Detective Maynard give Carmen Lauber a ride to anywhere other than Wasatch County Drug Court or her attorney's office?
just here to this building
To this building?
to
or
meet
this
with prosecutors or talk with her attorney. They're here.
Can investigators force anyone to speak with them if that person does not want to speak with them?
No.
Can investigators seize someone's cell phone without a warrant based upon probable cause?
No. It has to be consent or a warrant.
At any time, have you believed that the walk the dog letter gave you probable cause to seek a warrant to seize Ronald Darden's cell phone?
No, it didn't contain enough information for me to have gotten a warrant.
Did your investigation determine that the EpiPens recovered from the Richins home were for one of the Richins children?
Yes.
The GIF image, the one with Kevin Spacey that says idiots, idiots everywhere. Is that from the TV show House of Cards?
From my understanding, yes.
Thank you.
I'm sorry, is he finished? We have no further questions, thank you.
May we release this witness?
Yes, Your Honor.
Mr. Bloodworth.
Yes, Your Honor.
Detective O'Driscoll, you are free to go. You are released from any subpoena.
Thank you.
Thank you, sir. Mr. Bloodworth.
Your Honor, the state has a stipulation to admit. I don't even think we have to publish it. So if the state could, I think we marked it as 865. We'll
No
admit that
objection.
now.
Okay. Can I see it for a moment?
I think this will be great.
Your Honor, ma'am.
Please. Not open the door to this issue through any of the state's witnesses in the state's case of chief so far. I understand the possible order of events from this point forward to be they'll make a decision about whether in the defense case to open the door to it. If they do, the state would be able to respond by, among other things, publishing evidence of Mr. Jeff's statements and, forgive me, the other gentleman,
Bond Savage.
Mr. Bonsavage's statements as part of the state's response to or rebuttal of the defense's theory of a failure or to investigate or incomplete investigation. But they haven't opened the door yet, so I don't think there's any need or ability for the state to get into it in its case in chief.
Okay, Your Honor, then the state rests.
Okay. With the state having rested, Ms. Nestor, does the defense have a motion?
We do, Your Honor. Mr. Ramos is going to take care of that.
The state has rested. What are we doing? I'm sitting here with my eyes wide.
Your Honor, under both Rule 17-0 as well as 77-17-13, discharge for insufficient evidence, the defense presents the following and moves for a directed verdict. At the conclusion, this is just for the record, Judge, as Your Honor knows, at the conclusion of the evidence by the prosecution, which has just been done, the court may issue an order dismissing any information or indictment or any count thereof upon the ground that the evidence is not legally sufficient to establish the offense or offenses charged therein or any lesser included offense. Judge, based on the evidence that has been presented over the past 10 days or so, including all inferences, of course, that can be reasonably drawn from the evidence, it is the position of the defense that some evidence exists from which a reasonable jury could find that some, however, not all of the elements of the crimes that have been proven beyond a reasonable doubt. In terms of the sufficiency of the evidence, Judge, I'll start backwards, starting with count 5. With regards to the forgery, even looking at all the inferences in favor of the state, we do not believe that the state has proven a specific intent to defraud as it relates to the forgery. There's no proof that the signature was done without Eric's authority. And even assuming that the defendant, Ms. Richins, signed on behalf of Eric with or without permission, that itself does not conclusively presume that because she signed the name of Eric, that a forgery has occurred. The act, in other words, of signing another's name without permission doesn't constitute forgery, again, unless it was done with the intent to defraud, which we don't believe it has been met here. In terms of count 4, and forgive me, Judge, the way I'm approaching this is based primarily on the information, the criminal information, as the facts were laid out there. It was a bit difficult to follow through the testimony as to exactly what the state's position is. According to the criminal information, the basis for the true stage count 4 insurance fraud is that Ms. Richins, or rather True Stage left a voicemail with Ms. Richins requesting a copy of the prescription, any prescription Mr. Richins had for fentanyl. Then later that same day, Ms. Richins informed True Stage that fentanyl was not prescribed and that she had no idea how Eric obtained the fentanyl.
I think it's that last clause of that sentence that this is the state's prima facie showing. Do you see it differently?
And taking that as their basis, what the evidence has shown thus far has been that Ms. Richins sought and procured oxy from Ms. Lauber, that while Ms. Lauber indicated that it was fentanyl, her source, Mr. Crozier, provided fentanyl, that Mr. Crozier did not provide fentanyl. Rather, he provided prescription-grade oxy. From that moment, from the supplier, Mr. Crozier, to Ms. Lauber, The evidence is that what was provided was oxy.
May I ask you a direct question about that?
Sure.
Why couldn't a jury, properly instructed on the law and consistent with the court's duty when considering a motion for directed verdict, drawing all inferences in the state's favor, view the evidence as showing that Robert Crozier sold to Carmen Lauber 15 to 30 bluish pills marked M30. Carmen Lauber provided them to Kouri Richins, and then, based upon the testimony of Eric Haskell, that during that time frame, bluish pills marked M30 likely contained fentanyl?
Two responses. One, the testimony from Mr. Crozier as to the quantity and the amount per pill does not jive at all with the Haskell testimony as to how much fentanyl grade, or I guess street level, non-prescription pills were going for. What was indicated in the evidence was the amount that was paid was consistent with prescription grade oxys. So that's how I would answer Your Honor's question.
Okay.
Count 3, as I understand it, is that Ms. Richins, again according to the criminal information, had indicated a phone number with an incorrect digit, the signature on the application that purported to be Mr. Richins as a forgery. We talked about count 5. And then in the context, and I think it was also the P.O. box. I imagine they were trying to establish that Mr. Richins didn't have access to that or something to that effect. I don't believe any evidence has been presented to that degree, or that.
The P.O. box, circumstantial evidence that Eric didn't know about it.
Not necessarily.
If I view the inferences in the light most favorable to the state.
And even with that, Judge, I mean, there was no evidence presented at all that from the Postal Service or anybody saying that Mr. Richins had no idea that that P.O. box existed. There was a statement and a question made by, I believe, the state, but no evidence was presented to show that that was actually the case. That's how I would answer Your Honor's question. Also an interesting point. Term life insurance. At the moment that she allegedly signed on behalf of Eric and was submitted and was paid from her account, I am not certain that Your Honor could find that that term life insurance actually had value. What I mean by that is that there is case law, of course, in the civil process or context, that in the context of term life insurance, Utah courts have specifically addressed whether such policies have value as property. And the Court of Appeals in Beckham v. Beckham, I didn't write down the citation, I'll provide that, Your Honor, held that term life insurance policies generally have no cash value and therefore no property value. This is, of course, in the context of marital assets. So I bring that up. I think that's an interesting point. Obviously, it was marked for $100,000, but the actual value of that, I don't know, it raises an interesting issue.
Doesn't the statute talking about the elements of that particular crime for count 3 talk about property, money, or things obtained or sought to be obtained?
Correct. And that was going to be my last point, is at that moment, what the state needed to provide or prove, put forth evidence, is that at the moment that Ms. Richins allegedly signed on behalf of Mr. Richins for $100,000 term life insurance, that at that moment she knew that she was going to attempt to take her husband's life. And I don't believe they've met that, Judge. That's how I would answer that.
Okay.
With regards to count 2, and 1. Most of these arguments overlap, but I will attempt to keep them separate, Judge. As I understand it, in order for them to have met the elements, in order for Ms. Richins to be found guilty of an attempt, she must engage in conduct constituting a substantial step towards the commission of the offense. Here, evidence has been presented that she did seek to obtain oxy. We've had that discussion. Obtaining that oxy, just obtaining the oxy itself, is mere preparation. There is case law, as I'm sure Your Honor is aware, in State v. Johnson, 821 P2D 1150, that indicates that that is not enough. Coupled with the information that we just discussed as to whether it was oxy, whether it was fentanyl, I believe that's even Ms. Richins' case currently is even in a better posture than Ms. Johnson. So with that, if we look at it in the context of the Valentine's Day, there is no evidence at this point that what was obtained was fentanyl, 1. Even if it was oxy and she sought to obtain that, beyond that, there's nothing else, no other evidence that indicates that Ms. Richins took those pills, the greenish blue ones, I think at that time 15 milligrams is what Mr. Crozier said, and did anything else with it. I think the evidence as to Mr. Richins ingesting a sandwich is clear. In terms of Ms. Richins picking it up, absolutely. That his reaction was a result of that and not anything else, I believe that the evidence is scant. Your Honor has a question.
No, I'm following.
I will say that even in the Johnson case, the evidence was clear that the defendant in that case had actually obtained a specific type of drug, methamphetamine. So even in that case, they knew exactly what was obtained. Here, it's unclear what was obtained. I will add this before I forget. It relates to all of this in your prior question. In terms of the pills, Ms. Lauber testified the amount of pills that was significantly different from what Mr. Crozier had indicated, as well as the packaging. I believe that's important in the court's consideration in terms of what type of pills ultimately were given from Mr. Crozier to Ms. Lauber. This same argument, not to rehash it, applies to count 1. And it leaves us with the administering of the drug. Zero evidence has been presented besides that fentanyl was in his system, in his gastric, and it was possibly orally ingested. There has been no evidence in terms of the administering of whatever it was at all. Judge, for those reasons, the defense requests that Your Honor exercise your duty under both the Rule 17 as well as the Code, and we move for directed verdict on those counts, Judge, for those reasons, unless Your Honor has any questions.
I do not. You'll get the last word.
Thank you.
Your Honor, can I perhaps begin by asking the court if the court has any particular element that they would like the state to speak on?
No, I understand the standard. I believe I understand the state's theory. on each of the counts, especially 1, 2, 3, and 4. Speak to count 5 if you want to. Specifically, Mr. Ramos's argument regarding lack of believable evidence regarding intent to defraud.
Your Honor, it ties into count 3, right? It's the same insurance. This is the $100,000 true stage policy. And the scheme charge, the scheme fraud in count 3 is that Kouri Richins, at the time she took out that $100,000, well, this is interesting. The timing doesn't matter for count 3, but the timing does matter for count 5. That as it relates to count 5, at the time she forged Eric Richins' signature, she intended to defraud. I think the evidence that supports her intent is the fact that nothing on the face of the application indicates that Eric would know of this application, right? The mailing address, the email address, the phone number, everything, the payment, everything comes back to Kouri Richins. And she signed this, I think it was late January 2023, at a time when she had...
January 29, 2022, correct?
I'm sorry, 2022. It was the end of January 2022, at a time when she had already begun asking Hayden Jeffs and Carmen Lauber for drugs of some sort, at a time when she had already expressed her interest in starting a fresh life with Josh Grossman, and at a time when she had told Becky Lloyd that she would be better off if Eric was dead, and at a time when she had told Josh Grossman if he would just go away. So there is sufficient evidence in the light most favorable to the state that a reasonable jury could find that on January the 29th, when she forged Eric Richins' name, she had intended the entire fraud scheme that's charged in count 3.
Understood. Anything further?
No, Your Honor.
Okay.
Thank you.
Mr. Ramos, anything further, sir?
Just briefly, and this is, of course, if Mr. Bloodworth wants to respond to this, I did neglect in my argument initially as to count 2 the testimony regarding the joking nature conversation that Ms. Stakings had that she testified to with both Ms. Richins and Mr. Eric Richins. Of course, Your Honor heard that, so I would just add that for the record.
Understood.
Thank you.
Thank you. Mr. Bloodworth, anything further?
No, Your Honor.
All right, folks. I appreciate the argument. This is an important motion. Let me just take 5 minutes to collect my thoughts, and I'll give you of counts 1 through 5 in the operative information. It has long been established that the elements needed to make out a cause of action may be proven by direct and by circumstantial evidence. And if there is any evidence, however slight or circumstantial, which tends to show guilt of the crime charged or any of its degrees, it is the trial court's duty to submit the case to the jury. When evaluating a motion for directed verdict, the court is not free to weigh the evidence and thus invade the province of the jury, whose prerogative it is to judge the facts. Rather, the court's role is to determine whether the state has produced believable evidence on each element of the crimes from which a jury, acting reasonably, could convict the defendant. Not will, not would, but could. Moreover, the evidence must be viewed in the light most favorable to the state. Applying these legal principles as announced by the Utah Supreme Court in State versus Montoya, 2004, UT 5. The court finds that the state has established a prima facie case against defendant Kouri Richins by producing believable evidence of each element of each crime charged in the operative information. Defendant's motion for directed verdict is respectfully denied. Ms. Nestor, you asked for time to speak with your client to make some strategic decisions. Is between now and 1 p.m. sufficient time?
Yes, Your Honor.
Okay. Mr. Bloodworth, anything further before we recess until 1 o'clock?
Nothing further, Your Honor.
Ms. Nestor?
No, sir.
All right. We'll be in recess until 1 p.m., just confirming that to the extent the defendant will be putting on evidence or calling witnesses, you have a couple in the wings. Is that correct?
Yes, sir.
Okay. 1 p.m. Thank you for your time. Court's in recess.
Surprise, mother fricker. All right, let's see what we can do on our little skip to my loo. Oh no, we're getting close, brother. Please. We're back. Okay, we have maybe a few minutes to spare. What do you guys think, man? This is...
You don't want to.
I am going to pull this up.
Your Honor, actually, at this time, the defense intends to rest.
Oh!
We should probably do that in front of the jury, yes?
Right?
Okay.
I agree.
What?
I just want to make sure you've consulted with your client about this.
Absolutely.
Have they
Is
shut me
now
down?
an appropriate time to get a waiver of Ms. Richins' right to testify on the record?
Yes. Yes, you can.
Okay. You've consulted with Ms. Richins about her, or advised Ms. Richins about her right to testify, correct?
At length.
Okay. Ms. Richins, may I ask you 2 direct questions?
Yes.
Do you understand that you have the right to testify at trial?
Yes, I do.
Are you following your attorney's advice and waiving your right to testify at trial?
Yes, I am.
I accept your waiver. I find it's knowing and voluntary.
Yeah.
Okay, thank you. Anything further on the record, Ms. Lewis?
No, Your Honor.
Mr. Bloodworth, how would you propose we proceed from here for the rest of today?
Sir, let me backtrack a little bit on your earlier question. I think I should then rest in front of the jury.
Understood.
The defense can then rest in front of the jury.
What is happening right now?
I think then for the rest of today, and I propose tomorrow, the court recess, and that we begin, the parties can work on jury instructions perhaps today or tomorrow, but then we instruct and close.
Guys,
on
what
Monday.
is happening right now?
My face is not telegraphing any opinion one way or the other. I'm just waiting for a response.
I don't think we have a problem with that. I thought, we were thinking it might make sense to get the jury instruction conference out of the way, and then...
I agree with you. May we do it tomorrow? Give the counsel, both sides, a chance to talk to each other about any additional instructions you think might be necessary, narrow any differences or discuss any differences you have regarding any of those, and we can have that conference tomorrow.
Yeah, yes, that's fine.
Okay. So we'll talk about scheduling about
What is
that.
going on right now?
Just want to make sure we're all comfortable with the jury being out in the wild between now and Monday morning. Yes?
Yes.
Yes, sir.
Okay. Okay. All right. Are we ready for the jury? Mr. Bloodworth?
Yes, sir.
Ms. Lewis?
Yes, sir.
Okay.
There is no freaking shot this is happening right now. Guys, why can't I see the stream on my phone? What is going on right now? My phone was saying that I am something was super wrong with my thing. I did not expect this. It's over. It's over. It's over. Kouri, let's be 1,000. Kouri's defense was nada. They presented nothing. They showed nothing. They proved nothing in her favor. I don't know how you could possibly think she's innocent, because let's go through. Name one moment where you thought, wow, Kouri's actually innocent. She didn't do it, and this was all a misunderstanding. I'm not biased. I listened to the defense. I watched the evidence with you. There's no defense here for her. Zero. She didn't have anything good to put up that shows, hey, this was a misunderstanding. I didn't do it. It's if anything, it was the opposite. Everybody who came in proved everything that she did. Her conversations with her lover, everything. I'm sorry, it's over. It's over. That's it. This is it.
Please have a seat as you come in.
I just don't understand how you could think she's not guilty here. Right?
Have a seat. Thank you. Mr. Bloodworth.
Your Honor, the state rests its case.
Very good. Ms. Lewis.
Your Honor, after consulting with our client, the defense rests.
Understood. Thank you. Ladies and gentlemen, there is some legal work that I need to do with counsel in this case to get from here to the next stage. Rather than use your time inefficiently with you in the courtroom, we're going to do the following. We're going to recess for today. You will be on your own in the wild between now and 8:30 a.m. on Monday morning.
Whoa, 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 whoa.
I cannot emphasize this enough. Between now and 8:30 a.m. on Monday morning, please do not say anything about this case to anyone. I would understand if you had to tell somebody that you have to be back here at 8:30 a.m. on Monday morning. Other than that circumstance, please do not discuss this case with anyone. Do not allow anyone to attempt to talk to you about it. It will take affirmative effort and diligence. I need you to use that same affirmative effort and diligence to make sure you avoid watching, listening, or reading anything about this case from any source whatsoever. And please do not do any search, research, query, anything of any kind between now and 8:30 a.m. on Monday morning.
Bro, it's Thursday, dog.
Safe. Enjoy your weekend. I'll see you at 8:30 a.m. on Monday.
It's over. It's over.
Rise to the jury.
It's over. You ever seen Vince Carter? It's over. That's it. She presented nothing to defend herself in this case. The defense did nothing to help her. Her texts, her Google searches, her private conversation, her drug deals, it looks horrible. There's
All right,
not
folks, have a seat.
one credible thing that went into that.
May I propose the following? That counsel have an email exchange or a phone call, say 4 p.m.-ish today, about the state of the jury instructions and whether you think there need to be any additions or amendments. And then, to the extent there are, please send me an email or file something in the docket and let me know that you did. And then what time would you like to get together to talk about the instructions one by one tomorrow?
9:30?
Do you want to do it a little later just so I have time to look at whatever happens?
You suggest?
Late as possible.
You want to do it at 1?
Yes.
Sure.
Mr. Bloodworth?
Sure, sir.
All right.
Sure.
So you're all at least going to compare notes by the end of the day today. And if you file anything additional, you'll let me know by email. And I'll plan on being back on the record with you all 1 p.m. tomorrow. Mr. Bloodworth, anything else today?
No, Your Honor.
Ms. Lewis?
No, Your Honor.
Okay. Ms. Richins, 1 p.m. tomorrow. The court is in recess. Thank you.
Holy shinola mother fricka. I can't believe defense rested too. Guys, it's over. It's over. Look, we've talked about this from the beginning. We thought we were going to have 5 weeks of this. I didn't know how this was going to go for 5 weeks. Guys, it's over. It's over. Look, if you are someone who thinks Kouri is innocent, okay? This is no judgment on you. This is your opinion. You have to tell me why you think she's innocent. You have to explain to me what defense showed, other than her going, well, I don't know how the fuck they think I did this. That doesn't count. Just because she acts like she doesn't know what's going on in the world doesn't mean that she didn't do it, okay? She 100%, to me, through all of her private stuff, it's the private parts. That's not what I mean. It's the private moments, okay, where she was by herself, where the things that she said to other people, her book, her money thing. I mean, like the gifts, the planning, the fact that Eric ingested it. Come on, bro. Come on now. All right, ladies and gentlemen, we are not done for the week. It is only Thursday today. So tomorrow we are going to do a live. Like I told you guys, if you are a member on the Discord, we have a live there. I will let you know when that is. Patreon also has a live this week. And yeah, we got some other stuff we got to get to. But as far as everybody goes, tomorrow we're going to be doing a different live. But at some point, we're going to have to talk about this before it goes live on Monday. So I'll let you know when we do that, because we need to do a catch up from all of these days and go through the evidence ourselves, because there's just absolutely no way that the defense thinks it's all good. I know. Not her private parts. That was for her lover. I'm sorry about that. I'm sorry I said that. Anyway, we'll be back at it tomorrow. We're going to have to discuss this. So just be looking for a post. Love you guys. Appreciate you. Mods, thank you so much for everything. You guys are the best. Have a great rest of your Thursday, and I will see you tomorrow.